Recently, a legal case was filed before the Constitutional Court in Harare. It is a case that I will discuss. The citation, the full citation is there in the papers. We will not really go into depth about the full citation, but if you want it, you can follow it. It's for purposes of this discussion, we will say it's Fuzwayo versus ZANU PF Agenda 2030. And then our question is, who stands to benefit? So apparently it is a case that has been filed to challenge the ZANU PF resolution of 2024, resolution 1 of 2024, which seeks to extend the term of office for the president, the current president, beyond 2028 so that he can continue in the office until 2030. But as for all the other issues, I think we have discussed them. Many other people have been discussing them. This very channel does have several videos that try to address that issue from different angles. Please look out for those. So the background to the case is that, as you can see, on the 6th of November 2025, Mr. Mbuso Fuzwayo of Ibhetshu, likazulu pressure group filed a court application to challenge the ZANU PF Agenda 2030. Mr. Fuzwayo is cited in the application as the first applicant, and Ibhetshu, likazulu is the second applicant, and the respondents are cited in the order as follows. Respondent 1 is ZANU PF. Respondent 2 is the Minister of Justice, Legal and Parliamentary Affairs in his official capacity, that's nominio officio, and he's also the Secretary of ZANU PF. And then Respondent 3 is the Speaker of Parliament, also in an official capacity. The fourth respondent is the Attorney General, who's advisor to government. And then the fifth is the President of Zimbabwe, also in an official capacity. That happens to be Mr. Emmerson Mnangagwa, who is the intended beneficiary of this extension. And then people are asking questions whether the application is a good move or not. Mr. Fuzwayo himself, not my Fuzwayo, but Mr. Fuzwayo himself has circulated a video in which he explains his position on the matter and defends the decision that he has taken. That is Mr. Fuzwayo as the applicant. So as we look at it, there are some arising issues since the case was filed. The first one is the activation of the sub-judice scenario that is muzzling the critics. You see, because the application has been brought to court, it places issues that should be openly and publicly discussed under a juridical shield, because citizens discussing an issue of this kind currently before the courts risk crossing the line in a kind of a contempt of court scenario. That is contempt ex facie curiae. That is a contempt. We know there are two types of contempt of court. They can be contempt when one outrightly demeans the court while the court session is while the court is in session. And then we're talking about issues that are pending before the courts and commenting about them in a manner that is likely to, influence what the public opinion is on the court process itself, is a form of contempt of court. So by placing this issue before the courts, in a way, it muzzles the voices of the critics, because people now have to be very careful about what they discuss, how they discuss. As it is, I might be in contempt of court by even discussing this issue here. So those are some of the things to think about. Meanwhile, this is a subject that should continue in the public domain for quite some time until people find a solution to it, because it is not so much legal as it is political. It's a political question that must be debated in the corridors of power, in the streets, wherever people meet, they should be able to discuss this matter openly without fear of, crossing the juridical lines in contempt. So this case entangles the courts in the political debates and squabbles by calling upon the courts to meddle in party politics and to appoint the court as an arbiter of controversial skirmishes through lawfare. So the court is dragged into political debates, which in a way tarnishes the image of the institution of the court. And the application also invites the court to break the frontiers of the separation of powers doctrine by asking the court to instruct the legislature on how to run its own business. Section 167, subsection 2 was carefully crafted to keep clear lines as it keeps the role of the Constitutional Court advisory during the lawmaking process. Maybe let me just read section 167, subsection 2, so that we can contextualize issues. It says, subject to this constitution, only the Constitutional Court may advise on the constitutionality of any proposed legislation, but may do so only where the legislation concerned has been referred to it in terms of this constitution. So the role of the Constitutional Court in lawmaking is to advise the legislature on the constitutionality of an act or a proposed bill, whatever it is. And it does not come through maybe litigation by a citizen, but they are streamlined processes in terms of the constitution regarding how a bill should be brought before the Constitutional Court just for advice and so on. So that's what we have the advice. The issue therefore, the role of the court rather is to advise on the constitutionality of proposed legislation. And as it is clear that ZANU PF resolution is not proposed legislation. So no one has the right to bring it to the Constitutional Court, especially to apply section 167(2), because the ZANU PF resolution is just an internal ZANU PF political resolution, which has nothing to do with the people of Zimbabwe. It only becomes relevant to the people of Zimbabwe when it gets tabled in Parliament. Then people can begin to discuss it and debate it openly. And there is a concern that this case is stage-managed, choreographed, and simulated litigation with a predetermined outcome. So the general view is that this litigation risks creating a binding precedent that crystallizes the ZANU PF resolution into a legally compliant resolution far ahead of parliamentary processes. So in a way, it is an attempt to sanitize the ZANU PF resolution so that by the time it reaches parliament, the landmines, all these landmines ahead of it, judicial or legal landmines, they've already been cleared. So some people believe that this case is just one step of removing the hurdle and helping ZANU PF to have a smooth sailing process in terms of implementing this resolution. And the other concern is that a dismissal of the case will sanitize ZANU PF resolution and conduct and seal the destiny for future generations. Remember, if the Constitution is ousted through this proposed ZANU PF amendment or resolution, then democracy and this Constitution particularly will have died, because then it means that it is just a useless piece of paper. So looking at this, the questions then to be answered for purposes of the presentation are whether Mr. Fuzwayo really meant to file an abortive bid designed to pave way to the implementation of the resolution through the creation of a legal precedent that favors the 2030 agenda. That's one question. The other one is whether Mr. Fuzwayo's statement, in fact, let me say, maybe this one we can talk about this one after we've listened to the video clip, because as I can see, my analysis of Mr. Fuzwayo's statement should come after you've heard his own, through his own mouth. Otherwise, I don't want to preempt and shape the way you understand him. Okay, let's listen to him.
Good afternoon. I'm Mbuso Fuzwayo, the Secretary General of Ibhetshu. Yesterday, we filed a court case to stop ZANU PF extending the term of Emerson Mnangagwa to go to 2030. We believe it is illegal. Constitutional. So that's why we went there, and we are urging anyone who believes 2030 is illegal, 2030 must be fought, to align, support us in all these efforts that we are trying. I know there are those who think 2030 are going to coach will hate ZANU PF or hate ZANU PF after losing. It is unfortunate because we don't go to court because we want to lose, but we go to court to win. I know there are those who talk about the court being hatred, but sadly, I haven't seen a lawyer who is resigned to say, I can't continue in the profession that has been contaminated. They still take hands, go to court, and those who talk about my legal rep, who is Nqobani Sithole. Well, it's unfortunate because they want to link my association with Nqobani to Senges. It is unfortunate. I have been working with Nqobani Sithole as my legal rep, dating back from 2016. It is there on record. We went our first court challenge. Nqobani was in 2016 on the 22nd of December. Anyone who wants to prove it can go to Bulawayo High Court. We have gone. He has represented us in Matopo, Panagwe, where my phones were taken by CIO. I can't recall the year. There are those who want to associate us with ZANU. I think it's either they don't know us or they are people who believe us, because we will never, I don't think even ZANU can dream of opting us to aid it. It is a genuine application which we believe anyone can look into it and critique the merits. If it has gaps, people are free to join us. There is something that is called a joiner in court. They can join us, strengthen the court challenge, or they can. We have to do a lot of things to fight this thing. Thank you.
Oh, thank you very much. So now I think we can look at, we can try and analyze what Mr. Fuzwayo said. His statement, first of all, for my own observation, is ad hominem. That is, it is, it rests on on an argumentative fallacy called ad hominem arguments, whereby it speaks about the personalities involved instead of the merits of the bid. This principle, or rather this joke of saying, play the man and miss the ball. It sounds like that. So there are two possibilities one can think of. Either he and Ibhetshu intend to benefit ZANU PF for some hidden motive, or they have relied on bad advice. So while the first one is quite disdainful, because why would somebody want to benefit ZANU PF? The second one may be excusable and may be rectified if they are willing to rectify it. So talking then about the application, you find that this application is for an order of leave for direct access to the Constitutional Court in terms of section 1675 of the Constitution. And the Constitution is read with Rule 26.2 of the Constitution, the Court Rules of 2025, called the rules. Now, I will not burden you with procedural matters, save, of course, to say that what seems a little bit strange, of course, is that the bid seeks to rely on section 1675. But what does 1675 of the Constitution say? It says rules of the Constitutional Court must allow a person, when it is in the interest of justice and with or without leave of Constitutional Court, to bring a constitutional matter directly to the Constitutional Court, and to appeal directly to the Constitutional Court from any other court, and to appear as a friend of the court. So they are looking for direct access to the Constitutional Court because they could have started at the High Court and then taken the matter and escalated it as in terms of maybe to, if for instance a High Court had ruled against them, then they would appeal and so on and so on. Or the losing party at the High Court would then have taken the matter to the Constitutional Court and so on. But they are seeking direct access. Anyway, whether the Constitutional Court will grant them that direct access or not is something else, but it is likely to do so. And then the application says that Resolution 1 of 2004 by the respondent, first respondent, that's ZANU PF, infringes my right to equal benefit of the law, and the fifth respondent benefited from the existing law for him to become the president. A resolution that then seeks to extend the term of presidency is one which closes political space for me and any other persons who might have presidential ambitions. The interesting thing one might want to look at is that I'm not sure, maybe Mr. Fuzwayo is a member of ZANU PF. I don't know. I don't want to speculate about that. But the way I see it, he would have had a stronger case if he is a member of ZANU PF and he's not challenging this resolution in terms of the Zimbabwean constitution, but in terms of the ZANU PF constitution, because this is not a legislation, is not an act of parliament, is not a proposed bill. It is an internal ZANU PF resolution, which any person who's not a member of ZANU PF does not have the authority to stand against and challenge in court. So that's why I'm saying it might just be an act of a misguided challenge in itself. Because remember, this resolution was adopted in 2024 and not in 2025. So what we had in Dare was just a reiteration of the resolution that had already been adopted in 2024. And for over a year, ZANU PF did not act on the matter. So one might ask the question, why should there be urgency now? Why should we now panic about it? Because it has been there, they've been talking about it, and why didn't they initiate the processes for the whole year of 2025 until they went for another resolution at Mdare? So those are very critical questions to think about. So looking at the case, there are procedural and substantive questions to think about. Number one, has the correct procedure been followed? Could they have taken it by way of a motion, notice of motion application, or by way of a summons? Are there no contestable issues that it raises? And the question, another question looks at, in fact, the application seeks access to the Constitutional Court on the basis of Section 1675, which is a direct access provision and the procedural provision. We have looked at that. It does not address substantive merits of accessing that same court as captured by Section 1673 of the Constitution and 1672 as well. The Constitutional Court makes the final decision whether an act of parliament or conduct of president of parliament is constitutional and must confirm any order of the constitutional invalidity made by another court before that order has any force. So they couldn't rely on Section 1673 because the ZANU PF resolution is not an act of parliament. And neither could they rely on Section 1672, which we've already spoken about, which it says that subject to this constitution, only the Constitutional Court may advise on the constitutionality of proposed legislation. And then they go on to rely on section 1675, which states that rules of a constitutional court must allow a person, when it is in the interest of justice, and with or without leave of the constitutional court, to bring a constitutional matter directly to the constitutional court. So is this a constitutional matter, or it's a ZANU PF internal matter? Because before it spills out from ZANU PF and begins to affect Parliament, we can't really say that it has become a constitutional matter, because it becomes a matter of public interest and constitutional only when ZANU PF now take it outside of their structures and try to implement it at government level. Then that would justify Mr. Fuzwayo's stand against the proposition. So the substantive questions, the applicant claims standing based on section 85. So section 85 is a very wide section which provides at least 5 qualifying criteria for somebody to stand against any issue. And interestingly, if you want to understand maybe how the South African courts have approached this, you may just look for their application of section 38, because this section 85 is crafted in almost a similar wording as the South African section 38. So the question is, does Mr. Fuzwayo rely on all the section 5, all the 5 rather qualifying criteria in section 85? He relies on the Meda versus Sibanda precedent in his claim for local standing, that is the right to standing. Well, the court is likely to grant him that standing, and then if it is granted, then he will proceed with the application and pursue the relief that he's seeking. And the applicant invokes his rights enshrined in section 67 and 58. Section 67 is political rights. Yes, the right to vote. I think this one is quite reasonable. And then the right to access courts in terms of section 58. Well, again, I think there's nothing problematic about that. In fact, section 58 is freedom of assembly and association. I wonder how the ZANU PF resolution has infringed that, because remember, it's only happening within ZANU PF. The applicant claims relief on the basis of a cause of action which does not exist and has not occurred. Now, this is my point. The ZANU PF resolution is an internal matter which does not affect the rights of a Zimbabwean in general. So to rush to court and try to interdict a ZANU PF resolution as if it had any national application is in a way misguided. And I say there is a fatal omission of section 1672, which is disingenuous because the application fails to lay a valid claim against the resolution, which is neither a law nor an act of parliament. So the court cannot address itself to a party resolution, which is not an act of parliament. So that's asking the Zimbabwean Constitutional Court to make a pronouncement on issues that are strictly ZANU PF in nature, and you are not coming in as the ZANU PF member. So in that case, then the hands of the Constitutional Court get hamstrung. ZANU PF have not tabled any proposed constitutional amendment upon which the advisory function of the Constitutional Court would have been in order in terms of section 1672. So it's too hasty, too premature, and it has no merit. And joining the Speaker of Parliament is as odd as, since there is no pending legislative draft. There is no pending legislative draft, but maybe somebody would say you want to interdict the Parliament from acting. But again, as we will see, that would be very problematic in more ways than one. So looking at the merits of the application, you get the first thing is the applicant lacks standing, local standing in respect of internal ZANU PF resolutions. I think I've said that very clearly. The cause of action upon which the applicant seeks to rely is yet in the future, and litigation is premature. The case is poorly drafted, and litigation does not rest on solid procedural and substantive foundations. There are patent errors in the reading of the law because the applicant has been wrongly advised to demand a referendum as a requirement for amending chapters 5 and 6 of the Constitution. And that's contrary to section 328.6, because 328.6 is very clear that a referendum only applies when there is amendment of chapters 4 and 16. For it says, where a constitutional bill seeks to amend any provision of chapter 4, chapter 16, within 3 months after it has been passed by National Assembly and Senate in accordance with subsection 5, it must be submitted to the national referendum, to a national referendum, and it is approved. And if it is approved by the majority of voters voting at the referendum, the Speaker of the National Assembly must cause it to be submitted without any delay to the President, who must assent to and sign it forthwith. So the office of the President is in chapter 5, and the Parliament, the life and the tenure of Parliament is in chapter 6. So clearly, according to section 328, subsection 6, amending chapter 5 and 6 does not require a referendum. And that's why it has been done in the past, amending the term of office of the Chief Justice. There was no referendum requirement because, again, it was a constitutional amendment which did not require a referendum. So the applicant only challenges the proposed extension of the presidential term without challenging the extension of parliamentary term with which it is coterminous. Now, this is very, very interesting because by logic, when this ZANU PF Agenda 2030 is being discussed, there's going to be, if it succeeds, there's going to be extension of the presidential term of office by an extra 2 years beyond 2028. And nothing has been said about extending the life of the Parliament. And that is a deliberate silence so that people pay attention to the controversy around the president. And then, whilst there's this blind spot about what will happen to the Parliament. So you can't challenge the extension of the term of office of the president without at the same time challenging the extension of office for the Parliament. So you can imagine that that's why I make a claim that this this application was poorly drafted. It is very pedestrian in its nature because it only echoes, the sentiment that is in the street. It has not really gone deep into considering that the term of office of the president and that of Parliament those terms are coterminous. They run side by side. They are equal in length and in extent. So there is a fatal failure to question the extension of term of government in violation of section 32F and section 88, as well as section 117. Because amending section 912 only grants Mr. Mnangagwa eligibility to stand as a presidential candidate, but it does not confer upon him an extra 2 years of governance mandate. So who gives Mr. Mnangagwa, the president, and the Parliament an extra 2 years before 2028? Because if they want him to continue, ZANU PF are at liberty to then pursue a resolution, or rather an amendment that will make him eligible as a candidate. But in terms of him continuing beyond 2028, there is no amendment that has the power to grant that. Because if anybody does that, then as I'm saying, that would be in violation of sections 32F, 88 and 117. I'll elaborate a little more on those in a minute. So inviting the court to violate the separation of powers by interdicting Parliament from exercising its constitutional mandate, which is conferred under section 117, is problematic. Because to the extent that this application, among the reliefs it seeks, is that the court must interdict or stop Parliament from legislating. I mean, that would be clipping the hands of Parliament. The power to amend the Constitution is granted to Parliament in terms of section 117. So there's no way a court can interfere with that power in a vacuum. But that's why section 1672 then would be, that one would be contextual, because when an act of parliament or a draft bill is brought before the constitutional court according to procedure, then the court can explore and evaluate that proposition or that bill for constitutional validity. But to bar legislature in a vacuum, really, that would be in violation of the separation of powers principle, and that cannot be entertained. So when one looks at the analysis of the applicant's draft, in paragraph 34, it says, I therefore pray for an order granting me and the second applicant leave for direct access to the Constitutional Court. We say that may be granted or not granted, but it's likely to be granted. And then, if it's not granted, that's not a problem. Then the case dies there. But if it's granted, then we go to the next part. It says, if I'm granted leave for direct access, I will seek the following order: interdicting the respondents from taking steps to implement ZANU PF's resolution, pending the determination of this matter. And then declaration that section 952B and section 143.1 constitute term limit provisions under section 328.1. Okay, seeking a declaration. Is it in a vacuum? And then declaration that the implementation of the ZANU PF Resolution 1 infringes my right under section 356 and 67 of the Constitution, if sections 952 and 143 are term limit provisions. So in other words, this third prayer depends on how the second prayer has been determined by the court. So if the court says section 952B and 143.1 are not term limit provisions, then the matter falls away. And if it falls away, so what next? So does it then pave the way for ZANU PF to continue? You see, so in a way, that's why there is an apprehension that this court bid might just be an attempt to exonerate ZANU PF and pave way for a smooth sailing resolution. So that's what some people are saying, and let's go on. So the draft order invites the court to violate section 117 of the Constitution. That provision identifies the people as the source of government power, and it defines the legislative mandate of Parliament, and the power to amend the Constitution rests with the legislature. This is, we have it there, section 117. It says, nature and extent of legislative authority. The legislative authority of Zimbabwe is derived from the people. That is the part that I want you to underline. Derived from the people, and is vested in and exercised in accordance with this Constitution. The legislative authority confers the legislature the power to amend this Constitution. So there's really no way you can interdict the Parliament from, amending the Constitution, because that is the mandate given to it according to section 117, subsection 2A. So the argument really should be, it is illegal for the legislature and executive to collusively amend the term limit so as to benefit themselves, because it rests on a conflict of interest situation. That should be the thrust of any court bid. Not to try and be technical about it, because when you go to section 32F, section 88 and section 117, you will notice that it is the power of the people to grant the mandate to rule. Right. So in my summary of observations, I'm saying the use of application proceedings on a matter that raises contestable propositions teams with patent procedural flaws. For instance, the case cites the bombing of the Sappers Trust property, and it attributes that to ZANU PF without really any proof, and those are issues that cannot be determined just by exchange of papers. There will have to be a sharing or exchange of viva for share evidence, that is oral evidence. So the application proceedings would not have been appropriate. Rather, the summons proceedings would have been, because then ZANU PF must also have the opportunity, in terms of the principle of all the alteram patent, to be able to state what they know about the bombing or the alleged bombing at Sappers Trust. So how does the bombing of property justify an order barring the legislature from commencing its business of amending the constitution as enshrined in section 117? That is absurd, one would say. The application has been wrongly timed. It has come too early, since the course of action has not yet matured to justify any juridical intervention. And none of these processes, none of the following have so far done anything to warrant any interdictory orders. ZANU PF have not done anything other than resolving within their own organizational structures. They haven't gone out to try and manipulate the constitution in any way. So you can't take them to court on that. You know, the issues must play out in the streets. They are political in nature. So secondly, the Minister of Justice, Legal and Parliamentary Affairs, again, there's no bill before Parliament. So what is it that you are trying to bar him from doing, from receiving a bill? The Speaker of Parliament, again, what has he done? There's nothing tabled before him. And are you then trying to say by the time any bill is tabled, he must not accept it? But if he does that, then that would be in violation of section 117, subsection 2A. And then the Attorney General, again, what has government done? Because government hasn't started acting. That's why I'm saying it has come too early. This could have come at the right time. Probably when they have started all those steps, then you could have filed a case. But at the moment, there's no need to. And the president of Zimbabwe, what has he done? You're saying he is an intended beneficiary. Has he benefited? No. So at the moment, there's nothing that he has done upon which you may frown upon him and claim that he has violated any law, because he hasn't. So waiting until a draft bill on the constitutional amendment was tabled would have been in order, and the draft makes a fatal omission in failing to raise questions of legitimacy around the source of government. That is, I have already spoken about section 32F, section 88, and section 117, but we'll talk a little more about that one. Because extending power beyond 2028 is quite, it teems with legitimacy questions. Because on what basis does power extend beyond a 2-year mandate, which was given in 2023 as a 5-year mandate? So the draft rests on pedestrian arguments. I think I've said that, claiming that a referendum is mandatory for amendments of chapters 5 and 6 surely indicates that the legal advice given was not well considered, because it is doubtful if the council read the constitution before they drew these conclusions. A more diligent inquiry by council would have revealed that the arguments on the referendum lack any merit and any foundation. So you see, these are some of the issues that we have had to deal with. And now there's the question of legal ethics and the duties of legal practitioners. We are saying here that the application follows a notice of motion approach and yet raises contestable facts regarding alleged bombing of the Sappers Trust premises, and that would require evidence to be laid, viva share evidence or oral evidence, as I have said. And the ostensible ZANU PF resolution attached is drawn from site.zw.org.zw, a media house. You know, you say that you are bringing in a ZANU PF resolution before the court, but you bring a copy from a newspaper, and which the respondent is likely to deny. Where is the best evidence of the 2024 ZANU PF resolution Why didn't they seek a proper and authentic ZANU PF resolution to attach? So considering the patent loopholes in the draft, questions arising regarding the duties of the legal practitioners towards the public and towards the court, they arise. I mean, did the legal counsel really apply themselves to the case? And did they consider all other facts? Is this the best legal advice they could have given to their client? Or is it just a case of rent seeking? Did the legal practitioners exercise themselves diligently to explore the merit of the advice they gave to their client, and in applying the facts, issues, rules, application, and conclusion scaffold? Did they, lawyers, convince themselves that their client had a winnable case or not? Those are questions to be asked. And the draft of the case shows it as an abuse of legal process to achieve ends divorced from the pursuit of justice. Well, these are my own conclusions, because you can't really abort such a very important political process in Zimbabwe by applying rules of lawfare in a way that seems bent on maybe sanitizing a situation that doesn't seem as clean as it should to some people. So, of course, we admit that there's a place of citizen participation in civic and political activism. One would say, what's wrong with Ibhetshu and Mr. Mbuso Fuzwayo taking up issues where they believe that they have a case, they rely on the court. The uncertainties resulting from the shrinking political and civic space, distrust for parliament and executive overreach, cause anxieties among activists. So people become very anxious, frustrated by the shrinking space. Activists have resorted to lawfare as a tool to try and chastise and moderate executive power. So while the Fuzwayo application raises legitimate democratic anxieties about the proposed unilateral constitutional change, its procedural and substantive flaws risk producing a counterproductive precedent, which favors the current establishment. Those are some of the things. Yes, they have a point to make, they have a well-placed apprehension, but they should be calculative in their steps. A more strategic approach would have been to await the tabling of a tangible legislative bill in Parliament, which could then be taken to the Constitutional Court under Section 1672 or 1673. So armed with a constitutional bill or a piece of legislation, then the litigant could have launched a focused and specific constitutional court challenge, grounded on Section 328, subsection 7, which says that an incumbent must not benefit from a recent amendment to the Constitution. So they could have also gone ahead to defend the people's mandate on the basis of Section 32F, Section 88, and Section 117. So as a concluding remark, one would say the case is weak and lacks merit in many aspects, and the court is likely to return a negative verdict on the applicant, and if it does that, that would be detrimental to the civic or society and the political space. The applicant has not proven any cause of action. I have belabored that point because that's why I'm saying it's too early. They went to court on the basis of an anticipation that ZANU PF will break the law. But as long as they have not yet broken it, the court can't speculate that they will. So none of the respondents have so far conducted themselves in any practically unconstitutional manner, which the court may be invited to interdict. And the dismissal of the case will do more damage to the democratic space than withdrawing it will achieve. And in his mid-year statement, that's the video footage that we shared earlier, Mr. Fuzwayo has invited other citizens to join issue with him and to bolster the case. You see, the challenge is people are now being invited ex post facto to come and endorse what Mr. Fuzwayo and Ibhetshu have already initiated. But one might ask the question, why did they not consult widely with the people before going to court? Because this was not a private matter. This was, it has always been a public matter of concern. So instead of them going to court and then asking people to endorse it, they should have, first of all, consulted widely with the people. You see, this idea of going to court and then going there as a surge, you know, this issue of sagacity, where one is a sage, it goes up there as a savior and a messiah of the people, then people must endorse what has already been initiated. It's quite problematic in many ways, because as it is, not everybody believes that we should be litigating. And secondly, if we are litigating, the arguments, the case should have been built strongly in such a way that with wider consultation, a stronger legal argument would have been presented, instead of a hasty legal argument which is not well researched, which is most likely to be dismissed by the court at face value, and the damage created would be long lasting. We have seen that again not so long ago on the issue of Kukuraundi, when there were discussions in the social media about adopting the strategy called, what do you call this, what do you call, anyway, let me leave it out for the time being. But the strategy was all about using the courts to advance the people's cause. And then ZAPU just gets up one day, files a case, and before people know it, they are told that there's an agent ZAPU case at the Bulawayo High Court dealing with the Kukuraundi outreach program. And people they're left, you know, spellbound in a way, because now they are asked to support an activity or an action that has already commenced. They have not been part of the structuring of the arguments. They have not made any contribution, and now they just have to come and endorse. This advocacy by litigation has actually been, it is a very useful strategy, but it must be well thought out. So it is somehow odd for the applicant to invite people to endorse what he has already started. He should have consulted first. But if he's willing and he's sincere about it, then he must be willing to get back to the people and get people's advice on how to proceed. It's not too late to withdraw the case. So in the interest of the people of this country, pandering to the lawfare and gimmicks of the establishment is more damaging and more dangerous to the democratic expression and in shrinking the space than staying away from lawfare would achieve. So whilst the lawfare is always useful and effective, you should be very careful how you go about it, because you don't want to present a case that makes it very easy for the courts to dismiss it and set it aside on technicalities and on lack of merit. So the most advisable step is for the applicant to drop the case in the interest of the people of Zimbabwe, as the case seems choreographed and unwinnable. Then go back to the people and consult. If litigation is going to happen, let it happen at the right time, not prematurely. Thank you very much for taking time to be part of today's presentation. I certainly hope that it has, you know, shed some light on some issues. And as you continue to engage, I also look forward to hearing from you in terms of what you think about what has been shared, as well as what you think about this litigation and Agenda 2030 generally, and so on. Thank you very much. May God bless you. Bye-bye.